Weird, I don't know why your camera says it's on.
Good morning, everyone. Good afternoon, everyone. Sorry for the delay. So this is the inaugural meeting of the Rules Advisory Committee for the Oregon Government Ethics Commission to work on public meeting law rules. I'm going to start by mainly welcoming you and thanking you all for being willing to participate in this process. I'm going to briefly introduce commission staff that are working on the rules with me. We include myself. I'm the executive director here at the commission. With me in the room is Becky Mason. Becky can briefly
Hello, everyone. My name is Becky Mason. I am our agency programs administrator. And my pronouns are she and her.
Also with me in the room is Molly Putnam, we just gave her a new title. I don't remember what it is.
Accountability coordinator.
There you go.
That's me.
Then the third member of our committee could not join us today, but in our staff, Stephanie Hefner is our curriculum and training coordinator. And a lot of you on this Rules Advisory Committee may have had interactions with Stephanie. She's been very involved in the process of crafting some of these rules, and she will continue to be involved, especially as we move into the rules that address the trainings. So she will be able to join us at the meeting next week. And so now I wanted to give everyone an opportunity to introduce the members of the Rules Advisory Committee. I believe all of you have received a copy of the member list. What I wanted to say before we get to introductions is I want to briefly talk about what our process was in creating this RAC. We opened up that application process in late March, early April to try to solicit representatives on the RAC from all of the types of entities that would be affected by by public meeting law rules. So we have the various associations, but we also have representatives of the public bodies in those associations. So I'm going to start, and difficult to see if all of the members of the RAC are present, but I'm just going to go down the list and I'll call your name and please give us a brief introduction of yourself. So the first member is Adam, and I apologize if I mispronounce any names. Adam Aplanow from the Portland Metro. Is Adam here? Don't see him on the list. Woodward. Also with Portland Metro. You want to introduce yourself?
Well, it says they're not able to self-unmute.
What do I need to do?
Is it? Oh, it's the person, sorry.
I do apologize to you all. We're stumbling through a bit this afternoon.
Was it Beth?
Which one?
Okay, I can allow her to. I can let her present.
Okay.
Okay.
Hey, that worked.
Okay, there we go. Sorry about that.
Success. Hey, everybody. Good afternoon. I'm Beth Woodard. I am one of the attorneys with Portland City Attorney's Office. And in addition to doing litigation, I also oversee city council meetings. So it's a pleasure to be here and look forward to this work.
Thank you, Beth. Next member is Brenda Sanchez with Willamette Valley. Well, that's the region on my list. He's with a special district. Present. Okay, we'll move to Carolyn Shields. Carolyn's here, so.
If she was, okay.
Carolyn, do you want to try again?
Hi, everyone. I'm Carolyn Shields. Can you hear me now?
Yes.
Oh, okay. I'm with the City of Oakland, and I appreciate you accepting my application to be part of the advisory committee.
Thank you. Saw that Brenda Sanchez has joined. Brenda, do you want to introduce yourself? Brenda?
Yes.
Okay, I see you've given me, can you hear me now?
Yes.
Okay, I wasn't able to unmute and then I saw it changed. I'm Brenda Sanchez. I'm the district manager over at the Marion Soil and Water Conservation District. I'm thankful to be here today. Thank you.
Okay, next is Courtney Sneed.
Hi, everyone. My name is Courtney Sneed, and I wear a variety of hats in my community. I'm not sure why I was chosen. I live in Madras, Oregon. I serve as the executive director of the Madras Aquatic Center and Recreation Special District. I am a school board member for 509J Jefferson County School District, and I sit on a variety of budget committees because I'm the geek in the community. So thank you so much for letting me be here. I'm excited to represent Central Oregon.
Thank you, Courtney. And you do sound like you wear a lot of hats. Next up is Chris O'Grady.
Good afternoon, everyone. My name is Chris O'Grady. I'm the Legal Affairs Manager at the Oregon Department of Early Learning and Care.
Next up is Raghav Shan.
Good afternoon, everyone. Raghav Shan. I am one of the attorneys in OHSU's legal department, and I'm looking forward to working with you all.
Next up is Gabe Shepard with OAMR.
Hello, everyone. My name is Gabe Shepard. I'm the Deputy City Clerk for the City of Albany, and I'm here on behalf of OAMR, Oregon Association of Municipal Recorders. I'm the chair of that organization's legislative committee. I'm also a Corvallis City Councilor.
Another person wearing many hats. Next up is Hasina Wittenberg.
Hi there, my name is Hasina Wittenberg. I'm the Legislative Director for the Special Districts Association of Oregon. We represent over 900 special districts statewide.
Thank you, Hasina. Next up is Jeb Blandine. He's not on yet. Okay. Next up is Joe Barker. Hi, Joe. Hopefully you're here.
I don't see Joe.
Nope. Okay. I'll let you know, Joe's with the city, used to be with the city of Drain.
Joe Barker,
Yeah.
traumatized community member and trying to join teams.
That's okay. We're having our own issues, obviously.
Beg your pardon?
We're having our own team's issues, obviously. So yeah, I understand the difficulties.
Yeah, I'm just a community member at this particular point that has some knowledge of Brown Act law and public meetings law. So I'm just coming at it from a community standpoint of transparency and substance of that transparency. So thank you for allowing me to attend.
Of course. Next up is Corey Tate. May not be here.
I thought I saw Corey. Corey's here.
Oh, there's Corey Tate. Corey, do you want to introduce yourself? Okay. Corey?
Able to hear me now?
Yeah.
Okay, sorry. It wasn't picking
Okay.
up my other microphone. Thank you for letting me join. I work for Douglas County Government in Roseburg. I am the coordinator for the local Public Safety Coordinating Council, Behavioral Health and Housing, Impacts Mobile Crisis Program, grant writer for specialty court programs, and then the HIPAA Privacy and Compliance Officer. So thank you for having me.
Thank you, Corey. Next up is Chris Wright.
Good afternoon, everyone. I am Chris Wright. I'm a research scientist and I'm a planning commissioner for the city of Newburgh. I also have residency in a couple caucuses and I'm a member of the League of Women Voters. That's about it.
Welcome, Chris. Next up is Liz Souther Branch. Don't see her on the list yet. There is someone in the lobby. All right, so next would be Mallory Roberts with the Association of Oregon Association of Counties, AOC. Sorry.
Thank you. Hi, yep, I'm Mallory Roberts. I'm the Legislative Affairs Director at the Association of Oregon Counties, representing Oregon's county governments. Thank you.
Okay, next up would be Matthew Call.
I don't show him.
Don't show him being here yet. Okay. All right, next up would be Michelle Smith. Nope, I don't see her either. Nancy Sandoval. There's Nancy. Hi, Nancy.
Oh, Matthew texted, put in the chat, and Brenda said she's unable to mute as well.
Hi, good afternoon. My name is Nancy Sandoval. I'm here representing the Oregon Association municipal recorders. I am currently the president. I am from Eastern Oregon, city of Umatilla, and I am the city recorder there.
Thank you, Nancy. Next up is Rob Bovet.
Good afternoon, everyone. I'm Rob Bovet from Washington County, representing the Oregon County Councils Association.
Rob. Next up is Sarah Zavala.
Hi, everyone. I'm Sarah Zavala. I work for the Department of State Fire Marshal. I'm also the board administrator for the Governor's Fire Service Policy Council, and I believe that's the perspective I'm representing on this group. Thank you.
Next up is Scott Winkles from LOC.
Hello, I'm Scott Winkles. I'm a lobbyist on open meetings, ethics, and public records issues for the League of Oregon Cities.
Thank you, Scott. Next up, Sherry Kinsey. Okay. Next up, Therese Holmstrom, OSBA.
Hello, everyone. I'm Therese Holmstrom. I work for the Oregon School Board Association as an attorney, and I advise school boards at K-12 district, community colleges, and charter schools on public meetings laws, as well as many other things.
Okay. Next is Tiffany Johnson. See her. Okay, so we have at least 18 or more present, which would represent a quorum of the RAC. So if your name, if you didn't get an opportunity to speak, please let me know. Maybe put your name in chat.
This is Jeb Ledeen from McMinnville. I'm on audio only, maybe getting close to. Microsoft is telling me to send a code. Anyway, I'm a publisher of the News Register in McMinnville and here representing ONPA. Nice to be back talking public records with Scott and Rob and Hasina and people I've talked to about those for a lot of years.
Yes.
So glad to be part of the group.
Yes. Welcome. So, and please, like Becky has noted in the chat, the plan, of course, was to live stream this on YouTube or, I don't know, I'm a Luddite, so I count on my staff to figure this out. And I said some technical difficulties, but we will continue and post the video afterwards and hopefully figure out the YouTube streaming part by next week's meeting.
It is still available to the public right now. They do have live access. It's just not through YouTube. There is a Teams link where they can view. They just are not participants such as yourself.
Okay, excellent. Is anyone else joined that has not had an opportunity to introduce themselves? So, as I said, our efforts when we were creating the RAC and doing the application process, we were making a serious effort to try to get as many of the people affected by the public meetings law rules as possible onto a committee without making the committee unworkable. Hopefully, we have achieved that, notwithstanding our own technical bumps along the way. So the next discussion is process. So This is the first of a series of meetings. Right now, we have 3 of them scheduled. If need be, we may end up having more. We are going to step into sort of the initial, some foundational rules and definitions today. And how I envision this working is we will present the rules, we will have discussion, we will get feedback from you during the meeting. We will also have the opportunity for you to provide feedback after the meeting, as well as for there to be public comment and feedback as we are going along. And then at next Monday's meeting, we will spend part of that meeting going over the comments, any changes that we would make to the rules based on the feedback, and then hopefully have time to look at some of the additional rules or the next section of rules.
Oh, can we hold on for 1 second? We just got a comment saying that the public link is saying that he needs permission. So we do want to double check that real quick.
Okay.
Let's just right here. Hold on 1 second. We are checking something right now. I apologize. We are just checking some permissions right now to make sure everything is set up correctly on the back end. We thought it was set up, but there appears to be a slight hiccup.
This is Joe Barker. Permission to speak?
Oh, yes, of course.
I had that same message as well. Public link needs permission. And because I'm not using a live .com Microsoft email account, I couldn't sign in. Either or, so.
Well, it is a little different for the presenters because you as members of the RAC got a separate link than what the general public is having received. So your permissions by default and your link is a little bit different than what the general public is set up for. So
like I said, the email that you guys have is not the same as my live email account, and I have not sent you my live. I did send it to Stephanie to have me registered under the live so I could log in through the live account through Microsoft on Teams.
Stephanie is currently out of the office right now. So if you send it to her right now, that may be why she wasn't able to do that.
Okay.
We will do our best to iron out all these difficulties before next week's meeting. And we will continue regardless.
Thank you, Susan.
So overview of the rulemaking process. I'm fairly certain everyone here and plenty of the people here have far more experience at this than I. But we gained authority to adopt rules for the public meetings law as part of House Bill 2805. And so the purpose of this RAC and of this process is to start the process to get some rules in place, since there have never been any. The function of the RAC is to provide guidance, opinions, consensus, debate. Let me know where I'm getting too wonky or acting too much like an attorney. The rulemaking committee will also be asked to provide feedback and input on the requisite notices, the fiscal impact statement, the racial equity impact statement, all of that. And then in terms of the overall process, once we have had the rule advisory committees give us input and provided an opportunity for public input, the rules will be formally adopted or approved by the commission, and we will provide the requisite notices through the Secretary of State website and publish the rules according to their timeline. So that is my very brief overview of the rulemaking process. Becky, do you have anything to add?
We will also be sending out a post-meeting survey after every single meeting, either the same day or the next day. So that'll give you time for the people that like to mull information over. So that way you can send us your thoughts and write them all down. It'll be a question by question basis that way. Because I know some people like to take time to think things over and write out detailed thoughts. That way we can get that information in writing and be able to take that down. So just keep that in mind as well. So that way we'll also have that written record, and there'll also be an option for the public as well to submit written comment. And always you can send in your comments and thoughts at our email that's set up specifically for the rulemaking process at rulemaking@ogec.oregon.gov, which routes to our rulemaking team of Stephanie, Susan, Molly, and myself.
And so did you send out the Word version of today's rules?
I believe Stephanie was working on that right before she left. And let's see here. So we have, I don't know if she was able to get that out before she left for her meeting, so I do apologize, but we can also, Lex said she was going to upload the meetings, information on the screen. I believe yes, there is, and live, it should be showing on the screen now is the draft. It is also posted on the OGEC webpage. Thank you, Sarah. I knew she was doing something with it. She posted on the webpage. And it is also currently now on your screen as well.
Okay. I'm going to skip it because I want to get to the rules and so forth. I want to skip briefly over the break to overview of the public meetings law. Again, most of you in this room have years of experience with the public meetings law, but I want to talk about my approach to the rulemaking and the rules that we're going to look at today. And that is the public meetings law. If you look at it, it talks about sort of, and Scott, this may be familiar to some of you. I took sort of my approach from the LOC's Guide to Public Meetings Law, as well as obviously the Attorney General Manual, but the LOC Guide, which broke it into sort of 3 sections: the who, the what, and the how. And I liked that because a lot of what we did in crafting House Bill 2805 and the public meetings law in general, a lot of the questions that we get focused on sort of these initial foundational issues of who does it apply to and what does it apply to. So these initial rules were our attempt to provide some clarity in conjunction with the existing public meetings law of who counts as a governing body that would be subject to the public meetings law, and then what counts as a meeting that would be subject to the public meetings law. The how will be all of the more technical rules on sort of the rest of 192.610 to 705, the how to give notice, how to provide minutes, or how to conduct the meeting, accessibility, all those things. The details will be the how. But for right now, the rules that we have forwarded and posted are rules on who counts as a governing body and what counts as a meeting. So I think that is what we will start with. And I'm going to suggest, sorry for this, but a brief break now rather than waiting until 1:50. We will do our best to fix some continuing technical issues. Let's come back at 1:45, about 10 minutes, and we will kind of start jumping into the rules, the proposed rules. Okay? See you all at 1:45.
Good.
So Susan, how long have you been doing this?
Doing what, Joe? Or I think that was Joe.
Yeah. Oh, I was just wondering how long you've been with the teaching with the OGEC.
So I've been executive director here since January. Before that, I've been employed here since 2018. Prior to that, I was in Arizona where I was an assistant attorney general for antitrust and procurement fraud for about 8 years.
Nice. That's a lot of, boy, prosecution stuff. That's a intense area.
It's mainly looking at documents.
Oh, that's cool.
Hello?
Hello.
Okay, I'm here. This is Liz Olderbranch. Thanks. And
Oh,
I'm
you
very-
just joining?
Welcome, Liz. This is Susan Myers at the Ethics Commission. We already did sort of introductions, and we've been having some technical difficulties on our side, so I do apologize for that. But we took a break and we're now ready to sort of come back and start looking at the draft rules that have been posted to our website and emailed, I believe emailed to you. So we are going to jump in. The first set of rules that is submitted is 199050 subset 0005, which is some definitions. And recognize that these definitions are crafted to provide clarity. As I'm sure you can imagine, it is easy to go down a rabbit hole with these definitions. And some of these are suggested by our DOJ counsel as well. So let's look at the first two. Subsection 1 attempts to define communicate means to express or transmit information so that the information can be received and understood by other persons. Then communication is defined as the exchange or transmission of information. Subsection 3 is decision-making process. This means the process of making choices by identifying a decision to be made, gathering information, assessing alternatives, and making a decision. A decision-making process may include A, identifying or selecting the nature of the decision to be made. B, gathering information related to the decision to be made. C, considering recommendations. D, identifying and assessing alternatives. E, weighing evidence. F, choosing among alternatives. G, making a decision. And H, reviewing the decision and evaluating its impact. I want to take a break after those first three. Does anyone have any comments, reactions? And again, you don't have to give them to me during the RAC meeting. You can give them to me afterwards in writing or through email. Just want to give you an opportunity.
Did you say that you had emailed out a copy of the rules?
It was not emailed, it was just uploaded.
It's uploaded and posted on the website, apparently.
Oh, okay. All right, thank you.
I apologize. I thought, and we will provide an email copy afterwards, and as well as try to get an email copy of any new sections to you.
Chris also included a link to it in the chat as well. Thank you so much, Chris.
Yes, thank you, Chris. Okay, so moving on to deliberate and discussion. Deliberate means to consider information related to a matter that may come before the governing body as part of a decision-making process. To deliberate may include formal discussion of the information among members of the governing body. Subsection 5, discussion. Discussion means to receive and respond to communications. A discussion may occur verbally or in writing, and it may occur contemporaneously or over time. 6, defines discussion or communication that is part of the decision-making process. this term means the receipt and sharing of information and responses to information relating to any matters that are part of a governing body's decision-making process.
I have a quick question.
Yeah.
This is Sarah Zavala. I had a question about the definitions as we're going through them. If they aren't exactly the same as what's in ORS, do they need to be the exact same, or is this additional to what's already documented in the statute?
So what I was trying to do is not repeat what was in the ORS. If something is defined in the ORS, all I was trying to do was not put it here, but if need be, provide a little more clarification. So for example, deliberation in the ORS means discussion or communication that is part of a decision-making process. And so I didn't define deliberation, but I attempted to define deliberate because we do use that term. I'm trying to find the balance of making that work with the definition of deliberation. So to the extent that you think I'm not achieving that, trust me, feel free to let me know.
Just a suggestion, it might be helpful for readers or members of the public when looking at these rules to have that as an explanation in the first two sentences, saying that these definitions are not meant to replace the terms in the statutes, but should be used as further context or something with that as vetted with DOJ.
Understood.
That's a good point.
This is Liz. Can you hear me? Hello?
Yes, we can hear you, Liz.
Oh, can I have those, whatever that is, emailed to me? Because I'm not reading the same thing you're reading. I looked at the ORs. I'm not from the
I can email
website.
it. I will get a copy to you right now, Liz. Give me just a moment.
Okay. I will move on to number 7, intermediary or intermediaries. These terms mean one or more persons who facilitate communications among members of a governing body by sharing information received from a member or members of the governing body with other members of the governing body who are not present at the same time or in the same location. Okay, quorum. And no, I do not intend to define what counts as a quorum for anyone. No. Quorum means the minimum number of members of a governing body that must be present for the governing body to legally transact business. In the absence of a statute, ordinance, rule, charter, or other enactment specifically establishing the number of members needed for a quorum is a simple majority of the members of the governing body, of the public body. I need to tweak that. Any comments so far on these intermediary and form?
Sorry, this is Scott Winkles from the League of Cities. I'm not sure how to raise my hand on this format. I'm looking at deliberate and discussion, and that temporal reference. Well, there's no temporal reference on deliberate, so as it reads, related to a matter that may come before the governing body. And I'm not sure what words would address my concern, but I mean, that would require a lot of precognition on the part of elected officials to navigate. And the discussion definition reading, and it may occur contemporaneously over time. It's like, what is that? What is that time frame? So is it weeks, days, months, years? I mean, it could be, it just seems very vague to me that we don't know what time frame this would be subjected to.
Well, I don't know that I would be able to put that time frame in, given the nature of the public meetings law. If the question is, the public meetings law applies to, you have a quorum of a governing body discussing a matter or deliberating on a matter that is part of something that is understood to is part of the governing body's business, of the public body's business. They're going to be making decisions or recommendations on this, something related to the matter being discussed. So if my idea in putting the temporal language in discussion is, if you have serial communications, I was trying to distinguish between a discussion is not simply, you know, me and Becky having a discussion face to face. It could be me conveying information to Becky via email that Becky may not read until 3 days from now. It could be me conveying information through an intermediary and the communications going back and forth over a period of weeks or months, depending on the complexity of the matter that is facing the governing bodies. So putting an arbitrary time limit in the rules is problematic. That makes sense?
Yeah, I mean, I think an arbitrary setting the number of days or time frame is, I see that point. I still think that I'm going to noodle on this and try to come back with something for the next meeting, because I think there is a way to ensure that we're not talking about someone couldn't get hit with a complaint over a conversation that may have occurred 2 years ago. I mean, our decisions for cities on land use issues can take years. So, and no one's going to be able to foresee all those possibilities. So I think it's a must, but I think it has to be addressed, but I'm not sure how to do it right now.
Okay, I would welcome suggestions, but I toyed with this one a lot.
Do most of the city charters have time frames though, like at this meeting or convene to next meeting? Are those time frames included in in there?
No, I mean, if you just wanted to reference things that were already agenda, that's a pretty short time frame. But I don't think that's where. I think then you get into a legislative intent problem. I don't know. I'm going to try to come up with something for our next meeting on this.
Rob had some comments. Rob Ovett.
I do as well, but I didn't want to cut anybody off of the discussions they were currently having. Mine are a little different. I guess I'll go. So I need more time to digest these 3 pages of draft rules, because I just got them, of course, but I'm really struggling to understand some of these definitions we've already described and how they fit into the context of the 2023 legislation, where we did our level best to codify what's called the Handy decision, which actually technically wasn't good law, but that's a long explanation. It should be good law, according to a lot of folks. And so that's what we tried to codify. And when I crafted that piece of legislation and those definitions, I also went and cleaned up the exception statute, which is, oh gosh, what is that? 192.690. Yeah, and particularly subsection 1, paragraph M, an A, B, and C, and I'm struggling to understand how that fits within the exceptions provided in this third rule vis-a-vis the definitions, and I'm not sure it really works, and I'm quite frankly, I'm not sure I'm good with narrowing the scope of handy, because handy already narrowed the scope of what we could do, and I'm not seeing where you've baked in those exceptions, but maybe I'm just missing something.
Well, let's, valid
Like
point.
For
No,
example, yeah, 192/691M just completely exempts out communications between or among members of a governing body that are purely factual or educational in nature, you know, and then B and then C, there's
right.
And maybe it's baked into this rule here somewhere. I just haven't gotten to it where we're acknowledging these exceptions and we're not trying to narrow them or undermine them. But I didn't see them listed in the exceptions you had under 199.050.00155.
I did attempt in the Rule 15 to address them, so hopefully when we get there, we can address that issue further. And I am not attempting in the rules to narrow the handy decision any further. Your question is in 690 sub M, we has those three handy discussions, the, matters, factual matters, but that language from 690 that we discussed in 2805 was factual matters that are not related to the matters that would be subject to the deliberation of the governing body as part of a decision-making process. So it's not that all factual matters are automatically exempted. No, it's factual matters that are not part of anything subject to the governing body's deliberations.
Oh, no, I understand that. I wrote the words that are on that paper.
Yeah.
So I or that in the statute now. I was just summarizing, I didn't get into B or C either. I just want to make sure that what we're doing here, and I'll like Scott, I'll scrutinize it much more since I just now got it. But I'll want to object, quite frankly, to any further narrowing or expanding, depending on how you want to term it, of the handy decision. I think we did our level best, both in the definitions and in the exceptions, to codify it with legislative intent. And I'm not really interested in essentially confining local governments even more than they already are confined by those changes.
Understood. Are there any more?
Permission to speak. This is Joe Barker. My concerns are with the definition of intermediary and intermediaries in context to serial communications. When the serial communications go out to the full public body and the discussion is round robin and everybody has knowledge of what the other person feels, and by the time they come to the actual agenda item itself for vote, there is pretty much no discussion. The public has no knowledge of what their elected officials are thinking because those discussions have been held behind closed doors. And if I'm not mistaken, I think that was the whole pretense of handy, that serial communication should not occur and decisions should not be made behind closed doors. And I could be completely wrong on that. That's where the substance of transparency comes in at.
Right. I would agree with that.
Thank you. So I myself would include the city administrative officer, the office manager, anybody who has access and authority to communicate on specific issues, whether it's the budget, whether it's submitting contracts up, or, you know, the CAO.
Well, the difficulty, Joe, I think I think the difficulty would be to try to identify all potential persons or positions wouldn't work.
Well, okay. In the aspect of a chief administrative officer or city administrative officer, they're generally, that position is generally advertised. Their application is scrutinized, and they're, in theory, supposed to be sworn in under public law. That, to me, constitutes being a public official, whether it's appointed or elected. When you have upper administrative staff like the office manager, assistant to the administrator, those are all sworn in public bodies because their application has to be submitted. The bottom line is, our elected officials, whether appointed or otherwise, are spending taxpayer dollars. And there needs to be a red line of transparency.
Okay, valid points. My difficulty is defining intermediaries in a way that limits it in any way to a particular type of role or type of entity doesn't work for the definition, and that the definition needs to be broad enough that it applies not only to cities, it applies to counties, it applies to special districts, it applies to state agencies. So we can't put in there the definition that would tie it to a role.
Okay, if I'm not mistaken, I think ORS Chapter 2021 defines the difference between an elected official and appointed, but then it gets convoluted and throws both of them in the same sentence. And I would have to refresh on Chapter 2021 for that particular section.
Okay.
But yeah, 2021 does identify what I would classify as an intermediary would be. It's either elected or appointed.
So I guess I would invite you to provide me with a reference there by email, and I can look into that.
I can do that.
Additional comments before I move on? Okay. So I think I had left off at quorum. So serial communications. Serial communications means any discussion or communication by members of a governing body that is part of a decision-making process and that is held outside of a publicly noticed meeting. Serial communications may include verbal or written communications exchanged in person, through the use of an intermediary or intermediaries, or through social media, and may occur through successive or sequential communications. I'm going to fall on my sword here. The language of this is not the best. Again, Rob and Scott, this was attempting to make sense of the term in light of Handy and our discussions during the crafting of 2805. Welcome suggestions.
Also, Chris made a comment in the chat about being sworn in for a planning commission, and if that was not doing it, if it's illegal or not illegal. I don't believe that is public meetings law.
No,
it's not.
It really isn't
in our jurisdiction, so I don't think we can speak to that, Chris.
Okay, and then I added a definition of work session, and you can debate this a bit. So the definition I added was work session means a meeting held for the purpose of gathering information to serve as the basis for a subsequent decision or recommendation by the governing body. At a work session, a governing body may receive information and may engage in preliminary discussions, but members may not make decisions or take action. And Rob, this was very much sort of a attempt to distinguish in that 690M definition of factual information that would be subject to a public meetings law versus factual information that takes it completely out of the realm of a meeting. So if, go ahead.
My struggle with that is that different governing bodies use work session differently. I've worked for governing bodies that use work session to mean more than what you mean here. And in fact, just gathering information without any intention of having to make a decision on the matter at all. That can be a work session. And then I also have worked for governing bodies that use work session in the same way the legislature does, which means they are actually making a decision. And it's not like a public hearing. They do it separate from, and the work session is when they actually make a decision. So my struggle with that definition is that I've seen different people use that word phrase in different ways with a significantly different meaning than how you've defined it here.
Okay.
This is Gabe Shepard with the with OAMR. I wanted to also draw attention to that fact. Many of our different cities use work session to describe many different things. In some cities, they come to preliminary decisions that at the what's termed a regular meeting or something like that, then they vote on it. They get all the information and then they vote on it. Some cities vote during their work sessions. I've been a part of both types of things. So yeah, I had concerns with defining it as something where you may not take action. Many times in work sessions that I've been a part of, they have either directed through a motion or through thumbs up the city staff to continue working on something or make a few changes or do something like that. And I have concerns that this language restricts that.
Yeah, could we just think of another word? Because I really like this definition. But how about planning session or something similar that still gets at this sort of prep phase that you have to go through in order to plan for a public meeting? But just maybe calling it a planning session instead of work session, because I do agree with that distinction.
This is Brenda Sanchez with the Marion Soil and Water Conservation District. We hold work sessions, but properly notice it so that if a decision does need to be made. So yeah, that's going to have to be clear, please. Thank you.
So, all right, if I understand it, I think there may be two issues here with the definition. One, just what do we call it? And two, the limiting of, may receive information but not make decisions or take action. And I may have gone too far there. I see in my experience, which is not necessarily as broad as all of yours and is not limited to Oregon law. So in my experience, the work sessions that the bodies I used to represent held were in fact sort of that information gathering, but then the votes would only take place at a future regularly scheduled meeting. And I think that is a fairly common practice, but as you note, that may not be everyone's practice. So we may need to remove at least that second sentence and then deal with, do we call it a work session or do we call it a planning session? My worry about saying planning session is whether that would be recognizable as the equivalent of a work session. I mean, I can define it as such, but is that the right term, maybe?
This is Jeb Levine. I've always objected to the phrase work session for decades. A meeting is a meeting is a meeting, and a meeting is held to make a decision or deliberate towards a decision. Anytime when people say they're doing a work session, and particularly if they think that somehow is not a meeting under the ORS, they're just wrong. It's a meeting. They can use whatever description they want for what they plan to do at the meeting, but it's still a meeting. And to try to define and say that they can't make any decision, but they're going to be deliberating towards a decision, which is equally as important. So I don't know quite why this is needed in the rulemaking when it's not in the ORS.
My rationale, and sorry I keep looking to my left, but it helps because that's where your faces are. My rationale is try to clarify that language in 690. So in 690, let me pull up this right statute. In 690, okay, it says that the public meetings law does not apply to communications by or among governing members of a governing body that are purely factual or educational in nature and convey no deliberation or decision on any matter that might reasonably come before the governing body. So in my mind, that gives us a need to define or clarify when would a public meeting law apply to communications that are factual or educational in nature and do convey the information about deliberations or decisions. So this kind of sets up that schism, Rob, of there may be communications that are not meetings because they are factual and do not convey deliberation. But then on the other hand, if they do convey deliberation, they are meetings and subject to the public meetings law. And what do we call those? I mean, Jeb, I see your point. They're still meetings. Meetings are meetings. But is there a commonly understood term for such meetings? Is what I was trying to do so that in the rules we could distinguish this subsection MA language.
Chris Wright points out or asks, what about workshop as an alternative term? And then Therese asks, are we searching for how to describe a purely factual meeting that is exempt for public meetings law? I would agree that work session would not be an appropriate term for that.
No, and I was trying to distinguish, trying to make work session be not the purely factual exempt from public meetings law, but the other side of that coin, the factual that is still part of the process.
So kind of like the workshop, but not quite.
Potentially, maybe.
And this is, Therese, I don't know how to raise my hand in here, but I would, now that you've clarified that, thank you, Susan. I wonder how useful it is to define the exception, right? Since, the norm is that they are meetings, this exception of purely factual meetings that are exempt from public meetings laws seems to be, I don't know if it's useful to come up with like a term for when it is subject to meetings laws, since that does vary so widely, as so many people have pointed out. I worry that it makes it a little bit confusing to have that definition. I understand why you tried to define it, but I think it might create more confusion than help.
Permission to speak?
I'm sorry, who was speaking?
Permission to speak. This is Joe.
Go ahead, Joe.
I think I have two examples where a work session may be applicable, the phrase. One would be like, let's say at a city council meeting, they had wanted to know more information on a tax levy. So they would hire a consultant, but they didn't want to have that as part of the regular session because they're just fact-finding. They're wanting to know the ins and outs of the tax levy or something along those lines. You know, where it would be a 10-year financing compromise, existing tax base, blah, 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 blah. There, you know, so they would hire a consultant. The consultant says, well, I can't meet except for on Saturday from 1 to 2. In my mind, that would be a work session because they are basically gathering information, but they're not making a decision.
Right.
Okay. The other
We're arguing
aspect-
about the meaning of it. I mean, the right language for calling it.
Right. I mean, it would still be an open public meeting because it is a quorum. Okay. It is the whole public body, or governing body, however you want to put it. The other aspect would be, say like city council wants to get further information on ethics, how to convene a meeting, how to conduct a meeting, lobbying, what consists of that. But there are other nonprofit organizations that would like to be involved in that particular work session, so to speak. So, you know, I mean, it's a pick and choose gambit of what you want to classify as a work session versus what an actual public meeting is for discussion and vote.
Okay.
You know, but I think if the city council or the governing body wants further information and no action is being taken, via hire a consultant to disclose that information to them, I think that would be the exception there. But I could be completely wrong.
I appreciate the thoughts. Definitely see this as one definition that may need work. Obviously, I suspect all of them may need work.
Chris also put in the chat that it seems like you're trying to say work session is subject to public meetings law because it contains deliberations to come to a decision or recommendation. It does seem like the term deliberation is meant to cover the aspects of what is covered in the definition of the work session.
Yes. Like I said, jumping down a lot of rabbit holes. So, okay.
I would hope that in setting rules, we'd try to find a reason for this. What is the problem that we're trying to fix or address? I mean, we have not had these problems that I know about in our jurisdictions, but so I mean, with this and just in general, it's just sort of make sure that if we're creating possibility of inconsistencies between an OAR and an ORS and confusion, that we make sure that we're trying to address a real problem. That's just a side comment.
Okay, a valid point. I do not want to create any further inconsistencies. So yes, please let me know if you think the definitions create more inconsistencies or if they can be rephrased to clarify something that is in the ORS. In terms of addressing the real problem, the question is that we are getting a lot of questions from a variety of types of entities with concerns about whether if they discuss or hold a workshop or work session to discuss or deliberate on whatever it is, there is uncertainty out there whether that would fall under the public meetings law. And so would it fall under the exception in 690 or would it fall under deliberations as defined in 610? So all I am trying to do is see if we can use the rules to clarify when the discussions move from not being subject to public meetings law to being subject to public meetings law.
Understood, thanks.
Chris states in the text, or it's a text in the chat, from the agency perspective, I know agency staff have asked if work sessions or retreats are subject to public meetings law.
Yes. Yes, they have asked, not yes, they're not automatically. Yes, we have received those questions. And this is part of the answer. I think one of the other rules later on might address it better. So, okay, let's take another break before we move into out of the definitions and into the first substantive rule on who is subject to public meetings law. So come back in 10 minutes or so at 2:40.
Susan?
Yes.
Susan? The definition that I was looking at was ORS 221.160. It's special elections to fill council vacancies, appointment of council members when all positions are vacant.
Okay. I mean, I will take a look at that. I mean, obviously it's outside of our jurisdiction, but I will look at it to see if it impacts how we might define intermediaries.
Right, and I only raised that in context of between appointed and elected, because you have planning commission meetings,
right.
Or commissions, other entities that are created under the umbrella of city council. They're appointed to terms. They're in theory sworn in. They're in theory having to comply with open public meeting laws, posting agendas, transparency, blah, 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 accepting public comment, taking votes.
Public comment is not part of public meetings law.
Well, maybe that's one of the problems.
I am not creating new law here.
Oh, come on. You know I like to push the envelope.
Let's take our 10-minute break.
All
We'll be
right.
back. Okay, welcome back, everyone. Hopefully. Now we will delve into that second, the who question of public meetings law, meaning who is subject to public meetings law. So this is what I have attempted to address in rule number 199-050-0010. So I start with a sort of reminder, and I suspect LC will kick it out of the rules, but a reminder of the public meetings law, that it applies to all meetings of governing bodies of a public body for which a quorum is required to make a decision or deliberate toward a decision on any matter. So, again, I know that they don't want me to repeat the rules that are in the statute, the definitions in the statute in the rules, but in rule number 2, what I was attempting to do is provide some clarity, because a lot of probably state agencies more than any other body seem to have confusion on this. So all I did was take the definition in 610 and try to break it into 2 sections to provide that clarity, meaning a public body includes the state, any regional council, and any county, city, district, or any municipal or public corporation. And then separately, for any of these bodies, public body also includes any board, department, commission, council, bureau, committee, subcommittee, advisory group, or any other agency thereof. And again, my reasoning here is to a lot of state agencies that have created subcommittees or advisory committees seem to have confusion as to whether they count as public bodies or as governing bodies. So that leads me to subsection 3, which is a governing body means the definition in the statute is 2 or more members of any public body with the authority to make decisions for or recommendations to a public body on policy or administration. So what I attempted here was to clarify what that includes and what it does not include. And I do know the point about not wanting to define the exceptions, but a governing body would include A, elected or appointed public officials charged by statute, ordinance, rule, charter, or other enactment with the authority to make decisions for the public body. This would include county commissions, city councils, school boards, other district boards, etc. I have thoughts about whether I should include that last sentence, but my idea of breaking this into A, B, and C was there are specific governing bodies that by their very enactment are charged with making decisions for the public body. Elected, not always elected, but that is different from subsection B, which is members of any public body who have been delegated the authority to make decisions for the public body on policy or administration. A body meets this standard if its decision-making authority includes the power to exercise governmental power and act on behalf of the public body. So taking the language of authority to make decisions for or recommendations to, this would be that authority to make decisions for. And then subsection C was members of any public body who've been delegated the authority to make recommendations to a public body on policy or administration. This would include advisory bodies, committees, subcommittees. So I'm going to pause there and and let me know what you think.
Chris typed in the chat, from a state agency, there are also a lot of questions from staff about bodies that are primarily made up of individuals as designated by the tribal government as part of the tribal consultation process. It would be helpful to have some mention or nod to the 9 tribes within the rule set.
Absolutely.
Can you also include ports in the definition when you say this would include county commissioners, port commissioners? There's.
Yeah, I mean, what I suspect is DOJ and LC is going to kick out that language altogether. But yes, it would be ports. Dilemma is including all the specifics. It's cumbersome, but I do get a lot of port cases on my desk. So yes.
I don't think
Susan?
port. Oh, sorry. Go ahead.
Oh, sorry. I'm sorry, Nancy.
Just from my perspective, because Umatilla Port and Morrow ports are right next to each other, I don't think some of those commissioners know that they are subject to public meeting laws. And so I think if you actually just put it in there, then they can't say, oh, well, we're not included in that, because I've heard that a lot here locally on the eastern side of the state, which, Susan, I'm sure you've received a lot of cases from this side of the state.
The Morrow County, the Morrow Port commissioners, at least the former ones, do know that they are subject to public meetings law. But valid point, Nancy.
Susan, so this is Hasina from Special Districts, and I assume that DOJ is probably going to kick all this language out, but I think I'd be more comfortable just leaving. There's a definition in the statute. It's very clearly defined what a governing body is, and just leaving it at that, because I think we're just opening up a can of worms if you're restating something and then trying to further define what a governing body doesn't include when the statute is very clear on what it does include.
Yeah. And you may be right, Hasina, that they will kick all of this out. But I'll continue and we'll finish this section. So the 3 things that I was attempting to provide clarity on in terms of governing body not including, it does not include A, members of any public body that provide only factual information and do not have the authority to make decisions for or recommendations on policy to a public body on policy or administration. B, members of an advisory group that are appointed by an individual public official if they report only to that public appointing official, and if that official has the authority to act on the advisory group's recommendation. If the appointing official lacks authority to act on the advisory group's recommendations and must pass those recommendations on unchanged to a public body, the advisory group would be a governing body. And C, members of multi-jurisdictional commissions appointed by several different governments, including but not limited to those in Oregon, and whose Oregon members do not constitute a majority of the governing body members. All right, so that as you said, Hasina, they boot all of this out. My attempt in rule B, sub B there, is there's the language in the AG manual about governing body, an advisory group that makes recommendations to a public body. And so it has all that language in there of if you're making recommendations to the governor is not a public body, therefore you would not, a group that makes recommendations to her would not be subject to public meetings law. What I want to avoid is a group that makes recommendations to a public body that would otherwise be subject to public meetings law, making those recommendations to one member of the public body or to a member of staff, and then staff simply passing them along as a way of trying to pull themselves out of being subject to public meetings law.
There's a comment in the chat from Beth saying, couldn't the exceptions in subsection B possibly become intermediaries? And if so, how do they perform the work contemplated by B?
Beth, can you explain that a little bit more? What you mean?
Oh, I think this is the thing that I keep swirling around with the definition of intermediaries, which I know we covered, but to some extent, right, we've got governing bodies that do not include, you know, and then there's a list, but also some of this could become things that they're taking back, and then don't they become an intermediary? And maybe possibly my concern is best styled is I've got some comments that I'll submit in a written format with sort of the broadness of the intermediaries, but
okay.
I think, right, we're saying that the people in sub B here are not, right, they're going to be an exception, but they may get swallowed by the intermediary. That's and again, I'm probably best suited to.
I see. If, for example, okay, so that's what, a 9-member commission. So if I have a group of staff and citizens and whoever else that want to make suggestions to change the ethics laws or ethics rules or anything else, and they make those suggestions to me, and all I do is transmit them to the commission itself, that group would arguably be a governing body subject to the public meetings law, because I would, as the director, don't have the authority to change the ethics commission's rules. I'd have to look at the commission's delegation, but all right. I will look for your written comments. It might help.
Permission to speak? This is Joe.
As long as you keep it short, because I want to give everyone an opportunity.
Right. Susan, what I think you're describing here is the functional equivalent, which is found in Marks versus McKinsey High School fact-finding team, case number 878P2-PD 417, 1994, dealing with a public body record meeting. You're discussing a functional equivalent test, because everything that you described, whether a government entity performs a governmental function, the level of the funding, the extent of the government involvement or regulation, and whether the entity was created by the government. So, yeah.
Okay. Any other comments or thoughts that anyone else wants to share right now? I will say that most of this took me by surprise, in that most of the local jurisdictions out there, the cities, counties, special districts, seemed to have the grasp of governing body and advisory groups pretty firmly. It surprised me that the state agencies did not. And there are apparently a lot of state agencies with a lot of subcommittees and advisory groups that were not seeing them as governing bodies.
Hey, Susan,
Yeah.
Scott Winkles again. I'm looking at C, which, so members of a public body who have been delegated the authority to make recommendations, this would include advisory bodies. When we describe what's not a public body, I would suggest we have maybe a D, so a committee or advisory group that's advisory to staff is specifically spelled out and is not a public body. And the reason I say this, I'll use the example. I have a city that has formed an advisory group for their ball courts, because tennis players and pickleball players don't get along good, apparently. It's a thing for us, actually. So they put together this committee that's advisory to staff, and I would just like that sort of thing to be specifically spelled out and that's not a public body for this purpose. I mean, records would be open, but that's not, because it's.
Yeah, I mean, I think subject to getting DOJ to agree, but a definition like that would help. Is it in the definition of public body that is in 610? The question is, if they're making recommendations to staff, are those recommendations to the public body? I mean, in an ideal world, I would change the definition in 610 to kind of distinguish, like, making recommendations to the governing body of a public body, but.
So for us,
a bit of chasing my tail.
So for us, the only employee the city council supervises is the city manager in most cities. And so the staff are basically carrying out those directions. And so they're not advising directly to the city council at all.
Right. Which would be the argument.
It's just about performing their ministerial functions.
Right. All right. I like the idea. I like the idea, absolutely. I don't know if I can sell it to DOJ, but I will try. Because frankly, I think from a pragmatic perspective, it's kind of unworkable without that. I mean, then every meeting of every staff meeting becomes a governing body. It just gets crazy. So, yeah, I would welcome some language for that.
All right, I'll drop that. Appreciate it.
Any other comments or suggestions about who is subject to public meetings law and or who is not? Chris, if you want to send me some language about tribal consultation, like I had included tribal in this last exception under B sub C about multi-jurisdictional commissions, and then I took it out because I was trying to simplify it, but I would welcome some language there as well.
Of course, I can.
Susan?
Yeah.
This is Jeb. It seems to me that the element of only factual information could become a catch-all for all kinds of bodies that are putting together information which is sort of deliberative by its very nature. And I'm wondering if the whole process of how this factual information is gathered is not a public process, and so they're not subject to the public meetings law. And if in the presentation of that factual information, they should make any kind of recommendation, would everything that they had previously done have become a violation of the public meetings law?
So I hope not. My reasoning here to explain sort of when I was looking at the AG manual and some of the, well, when I was looking at the AG manual and trying to parse out who was and was not subject, the statute and the manual focus heavily on those two terms, make decisions for or recommendations to. And one of the examples given was, I forget if it was a library district, this might have been some advice issued at some point, but if you had a library that was looking for locations for a new library, and a subcommittee gets formed to go out and look at locations. Now, if the subcommittee is only making the is coming back and saying, we looked at A, B, C, D, E, these 4 locations, and based on the factors that you said you were important, we recommend site number C. It meets the best. That clearly is a recommendation to the public body. If instead what it is doing is we have looked and here are our findings. Here is what we found out about these sites. Site number A has, a cloud on the title. Site number B, whatever. And all they're doing is reporting and not making that recommendation. Then under the AG manual, they are not a governing body. But as you point out, if they take that next step, which easily can happen, suddenly they are a governing body subject to public meetings law. Now, does that mean their prior meetings were also subject to, or is it simply when did they become a governing body? At the moment they made a recommendation.
Functionally equivalent.
I really don't want to have to write an opinion on that.
Chris made a comment in the chat, by the way. I'm going back to the tribal comment saying that she can think through some language. Our staff in DOJ are trying to balance the role of state and work with tribes via tribal consultation that is honoring and does not infringe on tribal sovereignty. So I believe she'll be sending some language.
That would be great.
This is Liz on that whole fact finding. When you're like, we have a research in the commission that I'm in, we have a research committee, and that's only like 3 members. We can't vote on anything. We come back to our public meeting with just information on whatever subject area, whether it's education or whatever that we're working on. And we've gathered that information from the community sometimes, right? If we feel like there could be a recommendation at that point, we have whatever group that is come to the public meeting so we can consider it as we're still fact finding, we're still listening. We may not vote on it, but at the point that we may take it on as a recommendation, right? Because we're supposed to be gathering information from the public, from our constituents. So I like the idea of that when you were saying, now I'm going way back. Rather than it saying a work session, could it be more like a fact-finding session for one? And then are those, does that fall in the category of being still a public meeting? I'm just trying to not be confused here. Because when I look at the governing body and I look at the public bodies, both of them have commissions in there and city councils in there, So depending on where you are on your commission status and whatever community you're in, which is way different in rural districts than it is in urban district, and I'm in an urban district, right? Does that do all those things make a difference?
It does seem like the definition of deliberation in ORS is so broad as to bring all this into serious discussion. Discussion or communication that is part of a decision-making process. So it's going to be very complex and confusing to bring this down to all these times when communication that is part of a decision-making process isn't part of a public meeting.
Yeah.
Yeah, so tightrope time.
Oh, also, Chris made a comment in House Bill 2805, Section 2, ORS has a list of boards, meetings exempt from ORS 192.610-690. Should the public meetings law reflect these exemptions?
The public meetings law does reflect the exemptions. They're in 690.
Yeah.
Yeah. Yes, all of House Bill 2805 is in the current version of the public meetings law. So most of what we're talking about today is in either 610 definitions or 690, those exceptions to meetings.
And I don't know if this matters, but there are two active Chris's in the chat, a Chris O'Grady and Chris Wright. So
yes.
Just wanted to clarify, this one was Chris Wright.
Okay. Sorry about that, Chris.
So
does anyone think that we need, keeping in mind, obviously, that this may significantly change, but that we need further definition? Like, other than that, I like Scott's suggestion, and we'll look for his language about sort of staff and at some point trying to define any two people who meet in a hallway talking about government business as a governing body is going to be ridiculous. So if we can find a way of working that in, absolutely. And I didn't obviously list all the other public bodies whose meetings are not necessarily subject to the public meetings law because they're already covered in the statute, you know, peer review committees, etc. Okay, then let's power through to what meetings are subject to the public meetings law. So this is 199-050-0015. Okay. Probably going to get repetitive here, and this is where some of those definitions will come in. So subsection 1, a meeting is the convening of a quorum of a governing body in order to make a decision or deliberate toward a decision on any matter. So I may have taken liberties here, but I think they are necessary liberties. The liberty is adding the term quorum to this definition. And this is because we have gotten a lot of questions from various groups about if two members of their 5-member committee are meeting or are talking outside of a public meeting. And I'm like, my reading of what we put into the statute and of Handy is that that is not a meeting. It does not become a meeting until a quorum of the governing body is involved in the discussion. So, rule number 2, discussions or communications involving less than a quorum of the governing body do not constitute a meeting. Rule number 3, except as set forth herein, and I'm going to have to change that, except as set forth in the statute and in these rules. When a quorum of the members of a governing body convene a meeting to deliberate or make a decision on any matter, that meeting is subject to the requirements of the public meetings law. And I added the sort of, such meetings may occur in person, through video, telephone, or other electronic means, or through serial communications. And for private meetings where a quorum of the governing body engage in discussions or communications that are part of the governing body's decision-making process, violate the public meetings law. And that is regardless of whether intermediaries are involved. If you have a quorum engaging in discussions or communications on the public body's business, it needs to be a public meeting. So pause there.
Matthew wrote in the chat, discussions or communications seems repetitive as the definition of discussion includes communications.
I agree.
Chris Wright states, can a social media feed be considered a meeting if all the members eventually engage in conversation? We have thoughts on that one, Chris, and I believe our thoughts are yes. Well, my thoughts are yes. I will answer for Susan, apparently.
No, I have had a members of the city council reach out to me on this specific question of if one member of city council posts on social media, it was Facebook, this particular one, and then another member responds to with a comment. Now, it's 5-member council, so right now you only have 2 of them. But the minute that 3rd member comes in and responds, it becomes a quorum. Now, that then raised the follow-up question, which is, if the response is simply an emoji, is a thumbs up or a heart or whatever all the various emojis are, is that? I would argue it would be, because you are communicating it's the beginning of communicating a position. If you are responding to the comments on social media by indicating approval, that is a communication that could constitute deliberation, discussions toward deliberation. So, I mean, that was my initial response to the city that asked about that.
That's actually consistent with the advice we give.
Stolen much of the advice I give from your manual. So thank you.
Therese wrote in the chat, the rules in the section don't address how use of an intermediary can create a quorum. Good point, Therese.
I have that same question because I thought that's one of the reasons why House Bill 2805 specifically said that serial electronic communication kind of makes it sort of limits the ability to do that email communication in order to get that quorum or that agreement on a decision making outside of that public process.
Yeah.
I thought that was the purpose of that.
It was one of them, yeah.
To rule number 5.
Susan, actually, I have a question here. So the communication can be in writing, which that's fine. That's always been our understanding. But if, say, a counselor is going to introduce a resolution and sponsor it, and they get co-sponsors from other counselors, or they choose to co-sponsor it, that seems like it's a fairly common legislative practice for city councils in their legislative capacity. even if they're not being solicited, they just see it and they want to add their name to it. Is that, I mean, are they, I mean, it's on a calendar, it's going to be discussed, but I'm seeing a strict reading tells me that's a violation.
I think a very strict reading would say it's a violation, but at the same time, then how does the process, how should the process work if we can't do that?
I also want to refer back to the definition of convening, which specifically does say that serial electronic written communication among participants. It doesn't reference a quorum or anything like that in that definition, but it does specifically reference that in convening. So technically, emailing is convening a public meeting.
Yeah, I might need a bill for that. Okay.
Oh, and Brenda also put in the chat a comment about how serial communication becomes a quorum that needs to be addressed in the rules as well.
Yeah, it may end up being 020, so as opposed to being a sub rule here. I'm debating the last but one comment about sort of emailing about the meeting becomes a convening. One, and maybe I need a definition of non-substantive. This doesn't solve Scott's problem, but you know, we have the language in the exceptions in 690 about communications of non-substantive matters, and it gives the example in the statute of, you know, scheduling, leave of absence, you know, things not really matters that are subject to the decision or deliberation of the public body or of the governing body. So I think the sort of emailing it, but the question then for Scott would be, could you solicit co-sponsors? That strikes me as slightly more substantive to fall within that exception. Yeah. Take some thoughts.
Susan, if I may, the example I'm thinking of is that I have a 7-member board and one director calls or writes an email to each of the other 6 directors. That director has now spoken to all the other directors, even though the other directors only spoke to one person. So you have like one director talking to the individually. Does that make sense?
Yes. And they always do it by prefacing in their email, this communication is intended for informational purposes. Please do not respond.
Yes.
And inevitably, people respond. But if one member of a governing body emails 7 other members or 6 other members, and there is no response, you don't have a meeting. It's only a meeting once a quorum of the governing body engages in those communications, right? So that was why in rule number 2 here, I was trying to sort of say, because not everyone was, I don't know, you may not agree with me, but that if the discussions or communications don't reach the level where it is a quorum of the body, of the governing body engaging in it, I don't want to be the person that has to sort of monitor every communication among every governing body member. I don't have the staff for that. I mean, right.
Susan, are you going to be defining what engagement is for this purpose. I think the question was brought up, is a thumbs up considered engagement? Is a heart emoji considered engagement? Because you can respond to an email now with just a thumbs up or an emoji.
And I don't.
We always just put do not reply all.
Right, but I'm not replying all. I'm giving you a thumbs up in my email. I still responded or engaged. What is the definition of engagement?
Yeah, that's true. Maybe instead of putting respond, we put engage in there.
Well, I would have to define engage in the rules. And yes. Some of this in my head is the rule the appropriate place for it as opposed to some sort of opinion? Or I mean, at some point we will have to issue, a commission advisory opinion / manual similar to the AG manual that attempts to provide better context and provide examples in a way that you don't want to put every example into the rules. But if the consensus of this group is that we need to define, if we are going to be saying that communications includes thumbs up, heart emojis, social media emojis, whatever, we can put that into the rule.
I'm just saying from a millennial standpoint, I can have a whole conversation in emojis and memes and GIFs, and there's not one word in there. So what is I guess that's my question. What is the definition of engagement?
Well, I think that would fall under the definition of communications.
The exchange or transmission of information.
Chris Wright made a comment. Commissioners have to go through city staff to contact other commissioner, thus avoiding direct contact and comments through other commissioners, counselors, etc.
The worry there being, are they then making city staff intermediaries?
Also true.
Now, if it helps those of you who are or represent or could be city staff, it helps to keep in mind, under the public meetings law, you're not responsible for, the intermediary isn't responsible for following public meetings law. Hopefully you still would. It's the governing body members. So if the governing body members communicating with city staff, if their communications are, please share this with my fellow commissioners or counselors, that's problematic.
Susan, if I may, in response to Nancy's Sandoval's comment on, I had asked earlier, maybe the word information should be defined, and maybe it is, because if you say you like something or you love something, is that an emotion, and does that matter? Because you could be in a meeting and smile or indicate you may like or not like something. Is that information or is that just emotion? I guess. Something to think about.
Yes. Okay. I don't want to keep all of you later than we need to. So let's move on to my subsections. Subsection 5. Meetings and communications that are exempt from the public meeting law include And again, I did not list out all the exemptions in 690. For the most part, I was looking at the 690 sub M, what we added in the 2805, in House Bill 2805. I incorporated some language from earlier in the statutes, which is A, on-site inspections of projects or programs. B, attendance of members of a governing body at a national, regional, or state association to which the public body or members belong.
Oh, sorry. There was a comment in the chat that I missed. It's from Therese. It says, Susan, can you explain more how the instance where one board communicates directly with all 6 other board members is not convening a quorum through serial communications? Maybe I misunderstood.
So my example was the email message. So if a discussion is receiving and responding to communications, is one board member emailing out, I want the council or I want the committee to consider XYZ. If there is no response from anyone, is there receipt and response? No, it's just board member throws something out. So is that the discussion? Let me think of this, the community term.
You have discussions or communications involving less than a quorum of the governing body. Not constitute a meeting. So if you have a commissioner who blind carbon copies all 6 other board members and states, do not respond, this is informational only, they send it out and the other 6 board members actually reads and does not respond, then that is not a meeting because they are not communicating back and forth, they're not discussing, therefore there's no quorum, but they're still getting that information. It's informational only.
I mean, is it good practice? Not at all.
No.
Does it happen? Of course.
I believe that is the example that they were, you guys were using.
This is Therese. Thank you, Susan. That example was a little bit more restricted than what I remembered it. So thank you for clarifying.
Okay. Okay, so right now we're getting to see which it was my attempt, albeit a clumsy one, to address Rob the handy and that exception in 690 sub M, M, A or B. Communications among members of a governing body that are purely factual or educational. So meetings and communications exempt from public meetings law include communications that are purely factual or educational. And then such communications cannot include discussions of matters that could reasonably come before the governing body for decision or deliberation. So the purely factual or educational, not a meeting, but if they involve matters subject to the governing body's decision or deliberation, they are subject to the public meetings law at that point.
So like an ethics training, that's purely educational. It's not necessarily subject to public meetings law. But if you bring up the fact that maybe your public body violated executive session and you want to discuss that, then
well, you shouldn't be discussing those violations during our training. So examples of communications that would be exempt would include training sessions and retreats, so long as the discussions do not include matters subject to the decision or deliberation of the governing body. Sub 2, factual or educational communications that do relate to the governing body's decision-making process or involve matters that could become before the governing body for decision or deliberation are not exempt. Communications relating to those factual non-exempt matters must take place in a properly noticed work session. And this is where I brought in work session. I will fix that once we come to an agreement on how to describe it.
Do we need the second one if the first one?
I mean, frankly, I suspect Elsie and DOJ will kick it all out, but I was, again, trying to find that line in that 690 definition of if it's factual and doesn't involve deliberation, what about when it's factual and is on something that is going to come before the governing board?
It seems, this is Jeff, it seems to me that this section overrides all kinds of loopholes that I was concerned about, because part of the concerns that we have had is advisory committees that have been created and not even identified, much less made decisions as to whether or not their meetings were public. And this would, it seems difficult to believe there's a great many gatherings of advisory committees that would not involve communications on things that reasonably could come before the governing body for decision or deliberation.
Yes.
So I mean, this seems to, kind of override back, come back over the top of what was kind of confusing before. But so I welcome this language, and
well, you can always count on me to add confusion if possible.
Susan?
Yeah.
This is Joe. What I would do with under the second sentence where it begins with communication, I would make that subpart 3. And to make it fair and more clear, I would just delete the word work session, as long as it's properly noticed. And
properly noticed meeting.
Just
right.
properly noticed, period. Don't define meeting, session, just properly noticed. I mean, that,
Okay.
Both Chris's commented in the chat. Chris O'Grady put, I think the inclusion of retreat here could be confusing for implementation and a point of contention, because often a retreat is broader than just factual or informational in nature. That's a good point.
It is a good point. The language retreat there is taken directly from the statute.
Statutes.
Yeah. So, but maybe subsection E might help address Chris's point.
I'm really struggling with C little I, both sentences. It seems to me this would arguably prevent us from even in a one-way communication sending an agenda packet to our governing body.
I agree with that, and also sending out minutes as well. It seems that the only communications I would have with the governing body might be ones that relate to topics that they are providing information on.
Yeah, I'm struggling with this.
Would it help to address those points? Would it help to define, so in D, it talks about the non-substantive matters, which was part of that subsection M exceptions in 690. I didn't define what a non-substantive matter was, would it, I think the intent, Rob, when we worked on 805, that your intent there was based on the language in the statute, where you mentioned things like scheduling leaves of absence and similar matters.
Yeah, but this goes beyond any of that. I mean, this would prevent me from sending our agenda packet to my board.
I mean,
with all the attachments that would be posted as part of, you know, a public hearing process, for example. I mean, this would just this would freeze government. I don't get it.
I'm struggling to say that it certainly is not my intent to prevent sending the minutes or the agenda packets or anything else to the governing body members. I wondered if we could include that in the exception that's covered here by the Rule D of non-substantive matters such as scheduling leave and absence.
But those are substantive.
I know.
But wouldn't those be?
Yeah. Go ahead.
At the end of point 2 that Rob is indicating, why not put a comma and put excluding agenda and minutes?
But the problem is I can just keep rolling with examples that are just common standard practice of forwarding information that is necessary, is substantive for each of our individual board members to have. That they don't engage in cross communication, so there's no serial communication, there's no intermediary communication, but is essentially pushing information. If we limit it to just agendas and minutes, and then I'll come up with 10 more examples, and we'll come up with 10 more examples. This goes way beyond public meetings law.
Yeah, I mean, I can understand that, especially if you have a new council member and they don't know background history of how a parks plan came into existence or how you calculate electric rates through Bonneville, blah, 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 blah type of thing.
Pretty much anything you would send to board members with a note saying do not reply to all, or using your email system that precludes them from replying to all, which I think is a better practice. But pretty much anything you would push forward that doesn't have that interaction with public meetings law, this would just prevent.
Well, and I don't think it would. How?
Chris also made a comment related to this, saying as an agency, they post their board agenda and packet to their website concurrently while emailing it to the board. Would making those documents available in the notice requirements cover the concerns surfaced by C sub 2?
I don't think so.
I just think, I know the issue that we're trying to get to here, and I think what's confusing to me is like, those are part of our notice requirements or part of our public records, and some of those like public records seem a little bit different than meetings and communications, and trying to lob them all in together is creating something that is confusing, because I agree, if we couldn't send those board packets out as a matter of email to our board members, how else would we be able to communicate that information? And that in and of itself is preparation for the public meeting.
Yes. I guess I was looking at it that if you are sending your board packet and minutes, and as Rob says, I could foresee any number of things like that. It is still only a meeting. The definition of meeting is the quorum, is the communication by the quorum of the governing body. So you sending the agenda packets out to them isn't a meeting. It's if they start communicating about the agenda packets with each other that it becomes a meeting when you reach the quorum.
That makes sense.
This is Therese from OSBA. Is part of the problem that the language in C, the subsection C1 and 2, it doesn't mention meeting anywhere there. It's just talking about communications. Is that, and that seems like maybe that's the crux of the problem, but the subsection 1 and 2 under C just refer broadly to communications.
Okay.
And they don't restrict it to communications among members of a governing body. Is that maybe the problem?
That I suspect is the problem.
Taking a step back, the other Chris Wright made a comment. If commissioners and counselors go to a site to look at, does a public notice have to be given?
It's because it says on-site inspections are exempt, and it says that in.
Yeah,
it's in a weird location, but it does say that in the statutes.
Yeah, it's number 5A, but then on 5C, small double I, when it comes back here to communications relating to factual matters that involve information gathering related to a governing body's decision, must take place in a properly noticed work session. Now, if you're as somebody that goes out to these sites and you go look at them and it is a decision-making event, why isn't it? And then you do make use that decision in a meeting, why isn't it? Why then is on-site inspections or programs exempt?
That is a good point.
It is a good point, and I'm looking for where that language is. It always escapes me, but it's in 630, which is why.
Okay.
I think it's 630. No, that's the joint meeting language.
I know some of them is tucked randomly in weirdest spots.
Oh, it's in 610(7), subsection 7. It says meeting does not include any on-site inspection of any project or program or the attendance of members of a governing body at any national, regional, or state association, blah, blah, blah.
Okay, yeah, I see that. All right, thank you.
I mean, I think your point of if you're doing these on-site inspections and part of that is making a decision, whether it's while you're on site or otherwise, you know, the problem is that this exception from meeting doesn't specify that it has to be an on-site inspection that doesn't involve a decision. It just says on-site inspections.
Susan?
Yes.
Would it, as far as a safety practice is concerned, I can recall the City Council of Drain when they were inspecting their new wastewater treatment plant, even though it was not in theory a public meeting. It was the christening of it, you know, the opening of it. It was still publicly noticed that we're all going to meet here at this date, such and such a time, you know, if the public wanted to attend, so they could receive a tour. You know, It was just a PR thing. No discussions were made or anything like
Right.
that.
Right, that I suspect is a common practice of noticing some things as public meetings, just, well, you know, for public relations, but also just to be careful. So like when we send our trainers out to do ethics training or executive session training at a location, a lot of times the city, if it's a city or a school district, will notice it as a public meeting of their governing bodies because they will have a quorum and they just want to be careful. I think arguably it wouldn't fall under the public meetings law, but there's no prohibition on over noticing. It's not the best practice, but yeah. Okay, so it definitely needs work. I think definitely Teresa's suggestion of let's fine-tuning that language about communications and making it clear what we're talking about here is meetings among a quorum of the governing body will help. I'm not sure if it solves all your problems, but all right, so the last two are the communication, sub D, communication or discussion on non-substantive matters, on matters such as scheduling, and my phrasing there is bad, such as scheduling leaves of absence or similar matters that are not subject to a governing body's decision or deliberation. It was suggested that I come up with a definition of non-substantive matters. I have not done so. If anyone would like to come up with a definition of non-substantive matters, I would welcome it. Yeah. And then sub E, social gatherings and communications that are not related to any matter that could reasonably be expected to come before the governing body for decision or deliberation. So again, all of this is under the category of meetings exempt from the public meetings law.
Would ministerial fall under non-substantive?
I would have as much difficulty defining ministerial as I have defining non-substantive. I mean, maybe.
You know, like general housekeeping, like, okay, the municipal code is like 95,000 years old and we need to clean out all the blue laws. That's ministerial because you're bringing your working documents up to date. I don't know. I mean, because then if you apply labor laws to it, you know, your employee handbook, even though that's ministerial, it starts affecting the rights of your staff and your employees.
It becomes substantive pretty quickly.
Right. Yeah.
Oh.
Okay. Let's just throw Christmas party in there as non-substantive.
We already have social gatherings as non-substantive.
Well, as an example, then that way, you know, there'd be something to gauge. I don't know.
Okay, so next steps, send me some suggestions and comments and anything else. You can do it as a red line or you can just send me your thoughts. I will
Susan,
work.
are you going to send the Word version of this document for us to send you back our red line?
Yes, I will send a Word version out today.
Thank you.
We did have a couple of comments in the chat real quick. Matthew put under 5 is exempt the proper term, or would it be accept? Because .690 are exceptions to public meeting law.
Yes, I suspect accept would be the appropriate term.
And then Brenda put a situation where an on-site inspection might be public meeting. Board members are going on-site inspecting a completed project that will be voted on to pay the final invoice at the next board meeting or award a grant via vote by the board after visiting a proposed project site in a grant application.
I mean, I want to say that that would be subject to public meetings law. I'm not sure I can say that given the language in 192.610 sub 7B.
Okay, Susan, that cleared it up. Thank you.
I'm not sure it did, but okay. Visual thinking.
So we'll be sending out a survey probably tomorrow where you'll be able to type out your responses in depth for us as well. And we'll also send out a Word document to you as well. So you can redline it if you want. And then Rob also put in the chat, I don't really see ORS 192.690 sub 1 sub N sub B covered without it being narrowed. I'll put that in the comments I send you since we're at the end of this meeting. Thank you, Rob.
Yeah. Okay, so if setting an arbitrary deadline, if you could get comments to me or red lines, whichever, by Friday at noon, I'll be generous and work on the weekend. Friday at noon, I will work on seeing if I can incorporate them into a draft that we can share with you. So my vision for next week's meeting is to continue the discussion of these rules, see where we get based on people's comments and suggestions, see if we make progress on them, and if possible, move to the next section. May or may not happen, because I think there are going to be a lot of comments. So.
Oh, and Chris O'Grady put possible draft to start from non-substantive matters means having no significant impact on any matter that may come before the governing body as a part of a decision-making or recommendation process. That's a solid start.
I like that.
But then how do you define significant impact?
I was just somewhere to start.
I know. Like I said, lots of rabbit holes. So, okay, I appreciate everyone's patience with us. It's a start. We will make progress, and hopefully by next week we will have ironed out any of our technical issues. So, all right, I will let you all go. I will see you next week, and if you can send those. We will send out everything to you today and tomorrow, and if you can send responses by Friday, I would appreciate it.
Thank you, Susan, for an informative meeting, and everybody, great comments. It was really enlightening for me, and thank you so much for allowing public to babble.
No problem, Joe.
Thank you, everyone.
Thank you all.